Okay, we can start now. Thank you.
Okay. Virtual greetings, ladies and gentlemen. Thank you for your attendance, which is a testament to the relevance of the topic we are going to explore tonight with one of the world's leading authorities, Professor Mohamed Abdel Wahab. We have around 300 attendees from all over the world who just needed to click a few buttons to connect and exchange views. So again, ODR is very, very relevant. And with this, I need to extend my thanks to CRCICA and the CIR Egypt branch for facilitating this very important opportunity. ODR is not an option anymore. The COVID-19 crisis, if anything, was instrumental in revealing its already increasing importance, as well as shed the light on a big vacuum in the Middle East region. Personally, I find that we live very, very exciting times. As our ancestors lived through the Industrial Revolution and witnessed the world change, we have been and continue to witness sweeping changes in the way things are done. Kids do not understand how we functioned without a GPS, mobile phones, or the current breed of laptops. And with conflict being in the nature of life, conflict resolution followed suit and has branched into online dispute resolution, a field of its own. A field that is not just a virtual reverberation of ODR, as Professor Abdel Wahab puts it. These changes are not without risks. Many jobs, not only legal, will be eradicated. A new way of life must be found, and the road towards it can be very bumpy. However, I believe the future is brighter. With the globalization of ODR, an expression coined by our very special guest tonight, and with the rapid changes it is bringing, the face of the law and the legal profession is bound to improve, with the law becoming more simple and accessible in order to face the continuously changing realities. Young lawyers are now learning to code. International law firms are heavily investing in technology, just to cite a few of the changes that technology and ODR are bringing. Without further ado, I'm very pleased to present a learned professor who walks his own talk by remaining modest, striving to learn, maintaining the highest ethical standards, and sharing with rare generosity his knowledge. We have tonight Professor Abdel Wahab, who is a founding partner and head of international arbitration, construction and energy groups at Zulfikar and Partners law firm, the chair of private international law and professor of international arbitration in Cairo University. He's also a member of the ICA governing board, CRCICA advisory committee, MIAC advisory board, CMAC Court of Arbitration, Board of Trustees of the CIR, SIAC African Users Council, Arbitrator Intelligence Board of Advisors, and the Governing Board of International Council on Online Dispute Resolution. He also is the Vice President of the ICC International Court of Arbitration, Senior Vice Chair of the IBA Arab Regional Forum, Vice Chair of the ICDS Academic Forum, Dean and member of the Advisory Council of the Africa Arbitration Committee, international expert member of the China Permanent Forum on Construction Law, and fellow of the National Center for Technology and Dispute Resolution at the University of Massachusetts. He is also a seasoned practitioner who served as arbitrator, counsel, and legal expert in more than 200 cases involving African, Asian, Canadian, Middle Eastern, and US parties. He was the African personality of June 2018 by Africa Arbitration and the Lagos Court of Arbitration in May 2019. He received the Law Magazine 2017 Best Legal Practitioner Award, the 2018 ASA International Arbitration Advocacy Prize, the 2019 AYA Hall of Fame African Arbitrator Award, the 2020 Client Choice International Award. He also features in well-renowned legal directories such as Who's Who Legal Thought Leaders, International Arbitration 2017-2020, Africa's 100 List of Leading African Arbitration Practitioners by IR. And some of the well-deserved recognitions he received, the Legal 500 in 2019 states he's one of the best in the world. Who's Legal Arbitration 2020 says he is at the top of the market and a very well-prepared, exceptional arbitrator. It says in Construction 2019-2020 that he is a leading heavyweight construction law specialist whose analytical skills are second to none. Client Choice International 2020 by Lexology says Mohamed outshines his competitors. He is world-class. He is one of the most brilliant legal brains of his generation, an impressive, proactive, a very good speaker, and a very impartial and independent arbitrator. He was nominated 4 times in 2013, 14, 18, 19 for the Global Arbitration Review Award for the Best Arbitration Lecture Speech, and was also nominated in 2020 for the GAR COVID-19 Pandemic Response Award. As very relevant to the topic, he has authored no less than 15 publications on ODR, and is the co-editor-in-chief of the International Journal of Online Dispute Resolution. He also is the co-editor with Ethan Katcha and Daniel Rainey of the leading treatise Online Dispute Resolution Theory and Practice, which received the CPR Award for Best Dispute Resolution Work in 2013, with a new edition expected in early 2021. His most recent contribution was in May 2020 with his article, The Abdel Wahab Pandemic Pathway to Virtual Hearings, published in the Global Arbitration Review. And engineered by synchronicity, not by ODR, the CRCICA team found during its archiving effort a presentation by Professor Abdel Wahab in the 4th UN Forum on Online Dispute Resolution of 2006, where he was making the point that ODR is a reality, long before we awoke to it in the region with the COVID-19 crisis. And I invite you to have a look at this short snippet.
My presentation takes a different avenue and a different dimension to some extent, which I found to be appealing over the past 2 days when we hold the course. We held the course, the first international course on online dispute resolution. With respect to online dispute resolution and online arbitration, there are phases of development where everything is communicated online. You can have hearings and proceedings online in the form of video conferencing, teleconferencing, or whatever. And then to a fully fledged ODR system where everything is, or the AAA, everything is conducted online mainly, and paper-based becomes the exception. And the default global nature of these ODR services and systems are very clear. That is round-the-clock access and availability for all citizens of the internet or people who use the internet or cyberspace as part of their life. ODR is not exclusive for cyberspace or e-commerce or e-business, and it does not exclude other means. If in that part of the world we're not still familiar with the concept of ODR in principle, this does not mean that it's not a reality elsewhere. It is a reality and it does exist, so it's not in principle a dream anymore.
Well, those words could have not been more accurate. Now with the COVID revolution, we are eager to see if it's a blessing in disguise when it comes to ODR. Professor Abdel Wahab, the platform is yours.
Thank you very much, Fatma. I am speechless, and I'm speechless again because of the CRCICA team's efforts. This is the first time I'm seeing this video. I actually don't recall. I look at myself before I've done my sleep operation, and it's interesting. I'm very grateful. I think it's very difficult for me to put me actually off balance. But let me start. I'm very grateful for those who joined us and for again inviting me to speak on this topic, online dispute resolution and the COVID-19 revolution. And as the title suggests, I think that the choice was in coordination with CRCICA, that what is ODR? What are we doing? And did COVID-19 have a positive, negative impact? This presentation today is different, and those who may have seen or followed recent presentations that I have done in relation specifically to the impact of COVID-19 on arbitration or virtual hearings will find this completely different. So what I ask of our colleagues and participants is to bear with me during this presentation, because I will start on a different note, and then we'll get into the details, heavy details of stuff as a matter of law and practice. What I promise is the following. After this presentation, I think we will all leave with thoughts about where we are heading as a world and where artificial intelligence is taking us. Let me start. I have some slides I would like to share with you. So let me start by putting the share screen so that you can all follow me. So The first thing, as I mentioned, it's going to be a little bit unconventional. So this is my prepare for an unconventional approach there. Normally, I would have an outline setting out the stage of what I intend to discuss. It's a bit different this time. This is a question that I think we prepared a poll for. Our participants, what do they see in this? What is that? Perhaps they can assist us with the poll. Starting on a funny note, if we can all see the poll, is it up there? Yes, so can I ask everyone to vote what they see in this picture, actually? One funny thing that I included there, you see 4 different options. What do you see? And if we can ask everyone to vote and then publish the results, take just maybe 30 seconds, and then we can decide. Are the results published then? I like those who voted for Asgard. I'm into movies, those who know this about me. An energy bridge, a car. Well, 42% are absolutely right. This is a car. And you may wonder, what does this have to do with the ODR? I'm coming, just so I'm asking you to bear with me. But there we go. This is the image of it. This is a Mercedes-Benz car, the Avatar inspired. A model that is in the making. And we can now see this is the first ever car built. You see the first one on the left-hand side. This is a Mercedes-Benz as well, 1886, the first ever car. Now, this is what we see today. This is the visionary Avatar that they have. This has nothing to do with Mercedes-Benz, but it's an Uber fly taxi. So it's a taxi that flies, and again is in the making in certain cities and countries across the globe. Again, bear with me about this, because the commonality we've seen that they are more or less vehicles, and we see the change over time. Again, in the foreseeable future, are we going to see a flying car in a way? People think that this is a science fiction. But we'll get to see that. Moving forward, another question. I think, what is that? We don't need to. Yes, what is in this picture? If I can ask people to vote, is it a radio, telephone, telegraph, camera? What is it? Perhaps we can publish the results. That's what I thought. When I also saw it the first time, I thought it's a telegraph. It looks like using a Morse code. But actually it is not. It's the first telephone, and it's what Graham Bell has worked on as the first telephone we have. And today we have a handheld devices that are in the making, touch, smartphones, whatever. The upcoming version of it is that you'll have it like a malleable bracelet, a phone that is very thin, includes all the features over and above. And then again, the model they're working on, which is an energy generating bracelet, where you will have it on your skin, the phone and the reference to dialing, to doing all the features. It will no longer be handheld as such. What is the common theme, and what does all this symbolize when we look at the cars, the phones, and everything? The first thing is that change happens over time, the past, the present, and the future. And we look at this in awe to wonder what advancement and technology we have reached. The second thing is that what we've seen is knowledge-based and scientifically informed inventions of sorts. to modernize what we have seen from the past and create it to an extent in terms of be it automotive, audiovisual, whatever. And we've seen the relative evolutionary path of this through either the examples I've given in terms of the cars and the phones. But what is lacking? Now, I'm not going to answer that question now. I will answer it in the last few slides of my presentation. But I want you to keep that in the back of your mind, because we will return to that, because that will inform what I intend to mention and to share with you in terms of the concluding remarks on online dispute resolution. My presentation on ODR will fall squarely in three specific categories: the past, the present, and the future. And I thought it's important that we have this walk together through the past, the present, and hopefully consider the future, because a lot has been said during the COVID-19 pandemic and the crisis since it has hit the globe, that what we see, for example, in terms of just holding the hearings virtually, that is purely online dispute resolution, using just email communications, that is online dispute resolution, we will put that to test. So that is why I thought it is best to start with the historical overview and evolution, so that you are all aligned with me on certain facts that will inform the discussion on online dispute resolution. So let's start with the past. 1969 to 1992, the internet was invented, the ABRANET, which again was used for academic and military purposes. Disputes were very minimal. It was a closed, let me say, closed circuit population in a way. There was no issue. Up until 1992, where the National Science Foundation was managing the internet, lifted the ban over its commercial use. The internet, as it started, was not for commercial use, believe it or not. It was simply, again, for academic and military purposes. The ban was lifted in 1992. At that time, it was peaceful, limited online environment, no phishing, no spamming, no music downloading, no buying and selling, no multiplayers, no hacking as we know it today. Cybersecurity issues were not as we know them today, all these matters. Then 1992, we have the first internet service providers to offer commercial services. 1989 to 1995, the World Wide Web as we know it was invented, and the first ISPs provided graphical browsers. Those who are familiar at the time, and the new generation may not know that, the Netscape was the most popular browser. Amazon and eBay, and many of you would know eBay, of course, as a market, online market community, were established in 1995, and the online population began to grow exponentially. Now, based on latest statistics, we have more than 4.8 billion users worldwide, with Asia having the, say, the largest share of 55% of internet users. 1996, 27 years after the creation of the internet, we have the first ever article on ODR, online dispute resolution. In the Law Review, that was Ethan Katch's article, who is, by the way, labeled, and you have his photo there, the father of online dispute resolution. Ethan published his article, Dispute Resolution in Cyberspace, in Connecticut Law Review. And then the National Center for Automated Information Research sponsored the first conference devoted to online dispute resolution. The first significant online dispute resolution projects were launched, the Virtual Magistrate, as an online arbitration platform, just moving the traditional arbitration online as a simulation of sorts. Then we have the Online Ombudsman Office at the University of Massachusetts, and a family dispute ODR project at the University of Maryland. 2001, Ethan Katch published his first book on online dispute resolution, and I'm holding it there. I know the virtual background may not give you clear visibility, but that was the book published in 2001, and introduced the fourth party, which is technology. to the resolution of disputes. We all know that the parties to the disputes are figuratively referred to as the two parties. There could be more, of course, and then the neutral who helps them resolve the dispute as the third party, and then technology, the component in ODR, is the fourth party. Then 2002 onwards, we have more books and articles on ODR and the first ever online dispute resolution forum and the establishment of the United Nations Economic Commission for Europe expert group. And Colin Rule, who is also a leading figure in the world of online dispute resolution, publishes his book in 2002, Dispute Resolution for Business. Again, there, two founding cornerstones of the field. Absolutely. 2001 was the year when Ethan's book was out there. I was at the time doing my PhD in England, and I left the PhD and focused on ODR to try and understand the field and started publishing in it and joined the group then. It was my first ever speech, by the way, in Geneva, and you can probably see from the photo there. Then 1990s up until 2000, just to give you, rise in e-commerce disputes, spam, domain names, IPs. Traditional dispute resolution was not considered at the time to be appropriate, and ODR was used to fill the vacuum. Now, at the time, people did not pay much attention to online dispute resolution because it was for high volume, low value claims, marketplace. But the field has started to grow again exponentially, mostly at the time dedicated for cyberspace related disputes. Now, post social media, with the proliferation of online trading platforms, smartphones, and advanced ICTs, more closer to the reality we live in, we have seen more complex disputes, and ODR became a process tailored for both online and offline disputes, with also a focus on online dispute prevention systems, online dispute management systems, and online dispute resolution systems. 2010, the expert group, we thought at the time of hailing the UN and working with them on establishing an ODR working group in relation to online dispute resolution. And this is, by the way, the UNCITRAL Working Group 3, which is now the working group entrusted with investor state dispute settlement. And they worked until they finished their work in 2015, and the technical notes were released in 2016 January. In that case, we've seen in the last decade a movement from the human third party to an automated third party, to a fourth party. And this is not an anticipation on my side, nor is it science fiction. I will prove that to you. And we've seen also this accompanied by a move from small data, as we know it, normal type of computers as we have it, to supercomputers and big data on the cloud. And I will address that. This is just to give you the ODR task force, the expert group on online dispute resolution, which involves states, working group number 3, producing their outcome product in relation to the ODR process. And by the way, just the takeaways for it, it's for cross-border low-value sales, services contracts concluding using e-communications. That was the common consensus. It helped participants in an ODR system, and this includes the administrators, the platforms, the neutrals, and the parties. They reflected on principles of fairness, due process, transparency, accountability, but the technical notes do not promote any practice of ODR as best practice. It's still in the making, nor is it binding nor suitable to be used as rules governing ODR proceedings. This was not a rule-based document like the UNCITRAL rules on governing arbitration proceedings. No, it's simply a technical note of principles that people could review. Now, over the past decade, again, moving to the present, so this is the past so that you know where we're coming in terms of ODR. We've been fighting to promote ODR to the world, to say that online dispute resolution is well above and beyond using just simple electronic communications in traditional processes. But when COVID-19 hit, the world was forced into a situation of lockdown, restraint, curfews, and people had to work from home, live at their homes, for the fear of COVID-19. And in fact, until today, the very fact that we are on Zoom today is a testament that not everyone is comfortable with going out there. And so everyone acknowledged and believed. But amidst all this, everyone started referring to whatever is being done online as ODR. Whereas, a matter of fact, and we will see that, it is much broader than this. At the time, 2010, because I was not aware of the video, I did mention that it's an opportunity, but it will soon be a necessity. Well, the necessity has transpired, and this is where we stand. Now, the framework, again, I will not dwell much on this because I want to go into the more interesting stuff. For ODR, you need to have a proper framework. There is the technological factors, cultural and legal factors. The technological, of course, you need to have a proper infrastructure, connectivity, cyberspace, and now all the more data protection and privacy online, ICT and AI applications. I'm saying that because sometimes people do not distinguish information and communication technologies from artificial intelligence, and they are distinct, and I will come to that. And then we'll address the modus operandi of the technology used in ODR. So this is an indispensable framework. ODR does not work without technology. Then, of course, the cultural factors, trust and confidence, awareness, literacy, and the prevailing dispute resolution culture, which is the move from the traditional approach to dispute resolution, the transition into a paperless process, into the movement to a whole new subset of opportunities offered by online dispute resolution. And I know that many people contrast ODR with ADR, but ODR again encompasses online courts, and we will see that shortly. And then we have the legal factors. You need to have a proper legal regulatory framework for e-business, be it e-commerce laws, e-signature laws, or e-contracting acknowledgements. We know that in many parts of the globe, states are still sometimes grappling with acknowledging the value or evidential value of electronic communications and emails. But this is, by the way, changing at a very high accelerated pace, again, due to the COVID-19 situation. And then the legal factor in relation to e-dispute resolution and acknowledging the e-component in dispute resolution. And one specific aspect in which I have tried, amongst others, who have done excellent work in dealing with virtual hearings, to what extent do we have issues of or problems or concerns about the legality of virtual hearings? And I think many laws across the globe have embraced that. For example, the United Arab Emirates Federal Arbitration Act, law number 6 of 2018, expressly refers to the use of information communication technologies and video conferencing to hold hearings. And that was 2 years before the pandemic hit. The Jordanian arbitration law, the amendments that took place in 2018, also refer to the use of technology. And many arbitration rules, statutes, and legislation across the globe are either being amended or practice and guidance notes are being put in place to say, well, you can proceed virtually to the extent that cases are ready for this type of either hearings or e-proceedings in a way. Then we move to the $1 billion question, what is ODR? And I must confess here one thing, when we're discussing it at iCoder amongst the experts who've been in the field for 20 years or so, we don't have a unanimity. Believe it or not, there isn't. Some people say, well, any form of technology would qualify the process at ODR. So that is why I made it simple first. That's my first definition to you. We'll come to a more comprehensive one. Using technology to resolve disputes. I think this is the common denominator that people can agree on. To what extent and what level of technology is needed? What do we mean by use? All these come into play. Are we looking at an online medium? So is it simply because we are doing things online? Does that mean that it's ODR? Is technology used as a tool? Is it the type of the process that determines whether it's an online dispute resolution process or not? Is in-court excluded? What if courts adopt online technologies and use applications to resolve disputes online, with many courts now across the globe holding hearings online? Let me tell you, for example, the Supreme Court in Nigeria has ruled that it is not unconstitutional to hold hearings online. And many other countries across the globe have been doing so, and I will give you further examples. And so this brings me to the dichotomy that I had published years ago about technology-based, technology-assisted, and technology-facilitated processes and out-of-court dispute settlement. And this is the spectrum that I proposed to you. It took me, I think this is the slide that took me yesterday, the time to put it together. So here are the three components that I present to you. Online facilitated or online dispute prevention schemes. I don't intend to dwell much on this, but trust mark schemes, escrows, credit card chargeback, evaluation systems, feedback, online complaints. These are all systems that were mandated by the online environment, that businesses doing conducting deals online, or online marketplaces, or merchants who offer goods online. And I assume that since COVID-19, we have all been doing our fair share of online trading in terms of buying things online and delivering it to our homes in different parts of the globe. All these are schemes that are considered ODP, online dispute prevention, or technology facilitated schemes in a way. How would you trust that merchant? How do you know? You look at the ratings, the feedback from others. Do they have in place a system for credit card chargeback if they overcharged you? Do you put the money in escrow until the goods are delivered? All this in place. Now, this is not encountered in traditional offline type of trading, but is mandated by the online environment. And then we have the technology assisted ODR mechanisms. And here we have e-courts in place, and I will come to that, but let me start from the easier part, online ombudsman proceedings. So online ombudsman in relation to complaint handling, doing it online is not something new and has been in existence. E-negotiations, and by the way, here there are many online dispute resolution providers that have e-negotiation platforms. I don't want to name many, but we have more than 100 ODR providers worldwide. But I can give you one example, is a blind bidding process where you input in a negotiation process offers about what you're willing to settle on. The other party does not see your offer. They also input their own proposal. And if they match, the case settles automatically. Or if they don't, it settles with the median if the range of difference, depending on the provider, ranges from 20 to 30% or so. So here you have an immediate on-the-spot resolution of a dispute based on the willingness of people to submit bids that are concealed, not seen by the other or counterparty, and settle it. There is, of course, e-mediation. And I think mediation has moved online with mediators doing their sessions online. So that is, again, one aspect of the process. And e-arbitration, which brings us again to the question of what constitutes e-arbitration. Is it simply holding the hearings online? All aspects of the process done online? Is the agreement itself done online? Let me give an example. There is something now called the automated agents. We all sometimes receive spam emails about people selling you stuff and asking you to enter into a contract, even though this may not be your field. I, for one, receive emails saying, we are selling steel in certain parts of the world. Are you interested to buy? These are automatically generated messages that are mass mailed to people across the globe through automated agents, accompanied, if you respond, by a template agreement that is automatically generated, that if you agree will be signed and the deal is sealed. All this is automated, and it does include arbitration agreements. So imagine if you have an automated agent making an offer, an automated agent surfing the net to accept the offer, and the offer and acceptance are done by machines or automated agents. Would that be binding in legal systems? A question that remains to be answered, but that is the case. We also now see predictive justice applications, where in huge cases or in certain in-court proceedings, there are the use of computers and artificial intelligence to give you predictive outcomes as to what the arbitrator or the judge will rule. As to sometimes even in the US, they have in one interesting case involving a criminal, the artificial intelligence produced a report that if that person is released on bail, there is a 90% chance he would commit a crime. So this takes us back to the Minority Report movie and stuff. Should he be released or not? And the judge in that case is sitting in the US, when he was presented with this artificial intelligence, he ultimately released the person on bail because he said, I'm not going to trust 100% what the application would tell me. But of course, it is indicative of the path that the world is taking nowadays in relation to these types of predictive applications in a way. And then we have e-courts and e-juries, and I will come to that in a moment, where you have online netizens. These are citizens on the internet having problems, and they resolve them through crowd juries, where people register themselves as juries and they decide the case, be it a family dispute, a financial dispute. Again, this is happening as we speak. And then e-courts. And I will come to the e-courts because I will first go to that slide before I go back to the base systems. This is, by the way, a snapshot from China. This is an AI judge pilot project by the Beijing Internet Court. Now, just so you know, China is very advanced in terms of using artificial intelligence. And my poll to you is the following. Let me ask you this. Between February and March 2020, how many online court sessions do you think the Chinese courts have held during this just 1 month period? Or 1 month and 3 weeks, if you wish, or 17 days. But what do you think? Can you give us an answer? And this was during the pandemic. So I think it's interesting to see what people may think. It is something new, you know, you're holding court sessions online. In many jurisdictions, you've had few instances where hearings have been held online sessions. But in China, let us take this example. Can we publish the results? Very good. When I put the poll in the answer to these questions, I inserted the 55,000 specifically because I thought that this will be the number people will vote for. But it's not. It's the 110,000 that is correct. So let me tell you the following. There have been more than 550,000 cases filed online across China, and these are statistics by the Supreme People's Court in China. More than 440,000 payments done online in relation to those cases. They have held more than 110,000 court sessions and conducted more than 200,000 online mediations. So imagine this is just one case. And this is not just the end. In February 2020, the Beijing Internet Court published a procedural protocol of no less than 26 procedures spanning everything from logging in to protecting identities to dealing with the case. And it's not just the Chinese. Saudi Arabia, for example, have also established, and the Ministry of Justice, for example, provided a guidance note on remote court hearings. But then comes my question, and many other jurisdictions to you. The AI judge pilot project. What you see in the photo there is an artificial intelligence form taking the form of a human being and just assisting the parties with their case. And this is taking place as we speak. It's not something in the future. They are using intelligent synthesizing technologies of speech and image to help the Beijing Internet Court judges complete basic work in certain instances, preparing cases, providing statistics, looking at the arguments, all this. But also, we have the AI judge in the looks or image of a female, the voice and facial expressions and actions of a real person, so that you feel a degree of relatedness in a way. It's not robotic, it looks human in a way. And then it provides users and litigants with an online litigation platform. And as you see, the judge sitting there is an AI judge and real people addressing their case. It's not a complex one, it's a small claim, but this allows judges to focus their time on more serious and more complicated matters. So this is the tip of the iceberg. Today, you're introducing this as support services. Tomorrow, this may be all about decision-making and the human element disappearing, whether we like it or not. I'm not advocating for the disappearance of the human element. I, for one, as a human being, would like us to continue to do our work as we're doing it. But the question, will we be doing it the same way? Are we going to be doing it, or will artificial intelligence take over at least certain jobs in a way? And the statistics done in this respect is that they said that using artificial intelligence improves the quality and efficiency of judicial work and allows intelligent machines to conduct Q&A sessions, self-learning machines, being aware. And this is where the science fiction is now becoming a reality. So there you go. This is the present time. It is not the future. This takes me the ODR spectrum. Before I do that, I want to go back, and I think that's more important, to the technology-based mechanisms. Automated negotiations. I'll give you an example of the blind bidding. Advanced artificial intelligence solution set databases. Think of it this way. Ready-made meals that you can put in the oven and take them out to eat instantaneously. So you have, in certain cases, being of monetary value or certain complexity, artificial intelligence algorithms are being used to generate outcomes, preset solutions to the case, based on the knowledge base of decades of human dealings and excellent judicial brilliant minds of decisions, all fed into the system to generate solution set databases. ODR and blockchain. Now, just to give an example, many of you would know about blockchain, and Brandon Malone, our esteemed colleague, has given a lecture at the CRCICA and the CIRB Egyptian branch about blockchain and smart contracts. But let me tell you the following. Where does ODR fit? I'll just give you two examples. I'm not going to dwell on what blockchain entails, but of course, it's a technology relating to cryptocurrency and more than that. But where does online dispute resolution fit? Let me give you two examples that will be eye-openers on what ODR terms or what blockchain users and dealers would consider to be the online arbitration or online dispute resolution variant of what we know. And I give you two things. There is something called the Kleros arbitration system, and that is meant to address smart contract related disputes. The Kleros process can be activated once a dispute arises in the execution of a smart contract. So it freezes the fund transfer under the smart contract until the conflict is resolved. Now, how is the conflict resolved? For this to occur, the parties would pre-select Kleros as a dispute resolution provider. Think of it as an arbitration agreement, as a dispute resolution agreement providing for Kleros dispute resolution in the smart contract. They agree on the basic features of the process, and despite the fact that this is called Kleros arbitration, what you would agree, for example, is the Kleros subcourt composed of individuals who will pass a decision, and they are called jurors, online jurors. The design of the dispute resolution system developed by Kleros emulates some of the characteristics of the blockchain environment. It is premised on crowdsourcing, which means using the wisdom of the crowd, and game theory in economic terms. How is that done? Through jury voting. But how do you guarantee that jurors will vote or will have the expertise? That's, again, an essential question. Kleros offers a rights-based dispute resolution process, which results in a binary dichotomous resolution in favor of one party against the other. The process by which such resolution is reached is an aggregate of the votes of a large crowd of jurors who are specialists in subsets of blockchain disputes and smart contract disputes. So unlike, and that I think is an essential component, today you may go to someone and say, you want to appoint X as an arbitrator in a construction dispute. X can tell you, I'm a construction specialist. How would you guarantee that that person knows the ABCs of construction or able to sit in the case? Well, you would know when you get the decision or see him or her acting in the case or getting feedback ratings from others. But in this Kleros platform, if the juror registers themselves in a subset of a certain expertise and they do not render the right decision that is expected when you look at the aggregate of votes, that person is penalized and is considered to have breached the duty to render a fair decision and they will be fined financially because they advance certain coins or tokens in the online environment. They will lose them and they will be penalized further. So what happens here is that you're operating within a structure that aims to ensure the integrity of the voting process through a tokenized incentive structure and additional measures. The parties can appeal the decision if they don't like it of the jurors, and they can do that several times. But how does the system operate? You'll tell me, okay, then there is no an end, no finality. But each time the number of jurors will be doubled plus one. So this means you've got to pay more and deposit more funds to cover the appeal. And since costs would grow exponentially with this increase in the number of jurors, it is expected that this would be an inhibiting factor for parties to appeal any decision. They will think more than twice before doing it. Another system is called Juris. Juris offers an open code dispute system using blockchain and Juris tokens. Again, the framework adopts a Juris code in the smart contract. What happens here is a three-tier process. The first one is a self-mediation with a selection of tools, including mediation between the parties, to help them reach a consensual agreement over their dispute. Now, if that is not resolved, there is within the system something called SNAP, which is the simple neutral arbitrator pool. All these do not exist in traditional offline arbitration. And you see, this is a parallel universe of its own. So the SNAP is a process through which the parties receive a judgment by neutral, again, they call them jurors, who anonymously vote. But it's not just a simple voting, it's a reasoned voting. So the group of jurors provide an opinion, a reasoned brief opinion on the case. After receiving the juror's decision, the parties may then retreat to the self-consensual stage and try to reach an agreement if they don't want to implement the decision of the jurors. Now, what happens if they don't reach an agreement and they don't like this? You move to the final stage on the jurors platform, which is the binding panel. And panel here is an acronym for Preemptory Agreement for Neutral Expert Litigation. And this is very interesting. Despite calling it litigation, the twist is as follows. There is a judgment, call it an award. It is meant for the complex type of disputes with most experienced jurors who have the legal expertise and technological expertise. And here is the twist. You end up with a legally binding award enforceable under the New York Convention, which is known to people, again, as the single most important instrument for enforcement of foreign arbitral awards. So while this avenue is close to the SNAP, which is the second tier, the panel offers accessibility to enforcement under the New York Convention and can provide the parties with an award that is not only legally binding, but enforceable within the jurisdictions of the New York Convention. Now, the decision of the panel would be reached in 30 days, no more than 30 days. And the smart contract, if that is not the case, it will be rescinded and the award will be automatically enforced. So you see that our traditional approach to dispute resolution is coming heavily under scrutiny with this approach. And these are just two providers of many with different approaches to ODR and blockchains. The AI judge system, we've looked into that. The AI neutral, robotics mediators and arbitrators, is that the future? This is what I call the technology-based online dispute resolution mechanisms, where the fourth party is threatening the very existence of the third party. This is a statement I'm making for the first time, but it's a reality. We are now being challenged and potentially replaced by AI. Now we can say whatever we want, and I'm with you on this, that we want to maintain our jobs. But I will tell you in the concluding remarks, I will share with you something that will come as an extreme surprise to all of you. But hang on. So moving to the spectrum, what does ODR cover? We know that at least in arbitration world or in mediation, you can cover commercial, investment disputes, whatever, but ODR is well above and beyond that. It covers business to business, business to consumers, consumers to consumers, government to government, government to business, and government to consumers. And why did I put emphasis on government to government? Because I, for one, have seen a couple of years ago a system of an application on the basis of, at the time presented, as a possibility to settle state-to-state disputes that are highly contentious, highly political, where people are diametrically opposed and polarized. It builds on economic theories to reach an optimal win-win solution. So the artificial intelligence, you input your requirements, you share with the system the things that you do not wish to share with the other party. It comes up with your optimal position, and the other party does the same. The system does not share your views or their optimal resolution with the other party, but then being self-aware and conscious of your requirements, desires that you've inputted, it generates the optimal solution that is a win-win. Otherwise, the parties will lose on each side, and then you can make up your decision. That is a wholly, fully fledged artificial intelligence-based application. So this brings me again to what is ODR now from my perspective. I started by telling you using technology. This is the common denominator which all ODR practitioners can agree on. My version of it, and you can agree or disagree absolutely, is that now ODR has reached a stage, based on what we've seen, where you utilize state-of-the-art technologies that are integrated, embedded into the process that is wholly, or at least substantially, conducted online, leading to a necessary revolutionary phase that is matching the transition to a paperless world. And you integrate, again, artificial intelligence as the fourth party. Now, this brings me to what I promised you, which is IT versus AI and the use of algorithms. Now, artificial intelligence and algorithm generally is a detailed series of instructions for carrying out an operation or solving a problem. In non-technical terms, we use algorithms every day, like food recipes. This is an algorithm, by the way. Technically, computers use algorithms to accomplish certain operations and solving problems easily and quickly. And supercomputers, think of them as the serious super machines and not just the dummies many of us use. These are very serious pieces of work of artificial intelligence. One aspect, and I'm not going to dwell much on that, just not to waste everyone's time. There is something called the Nautilus. This was a project. It was a supercomputer that they fed into it 10 billion images and views of people and things, more than 300 trillion relationships, and then looked into the news from 1940 onwards, took that all on board, all the news, analyzed this, and generated certain predictions about human behavior in light of past practices over a period from 1940s up in 2015. Now, in 2015, it was, by the way, dismantled in a sense, but just to tell you, it is said, and that is, you can check it online, that based on that, the Nautilus was able to predict the whereabouts of Osama bin Laden within 200 kilometers, that enabled the troops to capture him at the time. So this is a very serious turn, not into the future, the present we're living in. And we need to see where this is going to carry us in a way. But again, big data and the clouds, these are large sets of data that are so voluminous that traditional data processing software cannot manage them. Cloud computing refers to the platform that allows you to access these sets of data. They're so voluminous. Just to give you an idea, the digital universe, the world's data in 2013 was about 4.4 zettabytes. And I have a question for you on the zettabytes shortly. But the idea that I want you to compare is that over a period of 7 years, we are now 10 times. It's more than 44 zettabytes. And what does that mean? Just so you know, it means a lot in terms of this 88 billion years of music files, 1.4 billion years of HD videos. And I think I can share with you, it's more or less 6.6 stacks from the Earth to the moon of data. So if you build up these stacks, 6.6 times the distance between the Earth and the moon. So just to give an idea about what the zettabytes, and I know many of us are not engineers or IT specialists, but we know about the kilobyte, we know about the megabyte, we know about the gigabyte, we know about the terabyte. Beyond that, there is the petabyte, the exabyte, and the zettabyte. And my question to you, look at the slide. That's should be an easy question. how many terabytes, the big terabyte that we have, in 1 zettabyte. Remember, we're talking about 44 zettabytes, the data we have now. 1 zettabyte has how many terabytes? Can you have a look and vote? So the answer is in front of you. The question is of getting it right. Can we see the voting? Do we have the results? Excellent. I think we have excellent decision makers. It's indeed 1 billion. It's obvious when you look at the shadowed zeros and you look at them, it's absolutely 9 zeros figure. But you can see that sometimes our eyes fail us in a way. But that's true. It is 1 billion. So 1 zettabyte, when we're talking about 44, and it's even more now because we are within the COVID-19 staying at home. Imagine 1 of zettabyte is 1 billion terabytes. Anyway, so the present again, this led, because of what's happening across the globe, IT, AI, and iCoder generally, iCoder, which is the International Council on Online Dispute Resolution, as a non-profit consortium, was established in 2017 in one of the ODR forums that took place in Paris. And you can see, of course, there Ethan Katch as well, the father of the ODR, the first person who ignited the spark, is there. And so are the others, Colin Rule and everyone else. And then the idea was to create this iCoder in order to promote access, use, and public understanding of ODR, engage with the development of ODR, promulgate standards and best practices in ODR programs, assist practitioners in becoming members if they have an interest in online dispute resolution, training, continuing education, mentoring. It is not administering cases. So this is not at all. It's simply a council to enhance our knowledge and understanding of ODR and ensure that more or less practices are streamlined or within the vicinity of best practices. Here are some of the things you can look online in your free time. The iCoder video arbitration guidelines, and I know many institutions have done excellent work in relation to virtual or remote hearings. The iCoder video mediation guidelines, you can check that. The iCoder payment best practices and payment ODR standards. This is where technology kicks in heavily on technical terms in setting the standards. And of course, you can, at your leisure, look into that. Now, this takes me to the future. And you can see that I'm taking certain images, and I will share with you each and every one. Now, the first one, AI and the brain. People talk about robots versus humans, artificial intelligence versus human intelligence. Well, the future, unfortunately, is not just about that. It's about the integration of artificial intelligence into the human brain. Think of it as neurochips that are going to be implanted to heighten and boost people's intelligence, memory loss, and believe it or not, they are using it now for restoration of optical nerves in eye surgeries, so that blind people can see, not in terms of their eye functioning, but they will be able, and there are prototype glasses that blind people will now wear, and you come across you on the street, they will be able to see you, not just see you, to have an indication through the artificial intelligence application whether that person is hostile or not, that person is happy or not. So look at the potential privacy implications of this when someone wears these glasses in a way. So there is going to be an infusion between human and artificial intelligence based on these microchips. Whether these tests are going to be successful or not remains to be seen. What implications may this have is another thing. And you see on the right-hand side, like an energy belt. And this is my take on it in a funny way. We all see COVID-19. And despite all the views expressed by people across the globe on how it is transferred. Are we going to see viruses in the future transferred virtually to us? Not just virtual viruses infecting machines, infecting humans sitting in front of those machines based on energy pulses or electromagnetic or whatever. I hope not, but imagine what this would be like. So you can't go outside, you can't stay inside. It's going to be devastating. And the third one is an image of a project. You look at the robot that is a little bit bluish there. This is an image of a project called Discern, which is a collaboration between the University of Texas at Austin and Yale University. What they wanted to do is to mimic human experiences in terms of neural impact and the dopamine, let's say, within the human body. The dopamine is responsible, by the way, it's a chemical substance that the brain uses to stimulate neuro and mobility functions, so many things about the body, the movement, the functions, high adrenaline, the feelings of goodness, a lot of things. So what they did is that they brought this robot, and one of the main instructions, it's a self-learning in a way, they added stories, historical events, everything, and they told the robot not to forget anything of that. So the memory was working to memorize everything and nothing to be forgotten. What happened after that, to test how the robot handled that instruction, and looking at these stories with fascination, it's self-learning in a way, is very interesting. We have the first schizophrenic robot. What happened is that the robot looked at some of these stories, and the ones that apparently the robot liked or for some other reason, implanted itself into those stories and taken a role and believed that it is part of these stories and the storyline and the dramatis persona of this story. So it implanted itself as part of the figures, the story, and the identities that exist. So this was a very interesting test. You see that people are testing artificial intelligence and robotics across the board. Again, what implications this may have into the future. This brings me to the last picture there, which I hope we don't reach, a robot holding the human skull. I won't be alive at the time, but I think we need to be cautiously look into what we are wishing for and what we are doing in a way. This brings me to the question that I promised you we need to consider, and I'm coming to an end, and I hope I've not imposed much on your time, which is what you're looking at the moment. Remember the cars, remember the phones, and what is lacking. There is a common theme, which is said change over time, knowledge-based and scientifically informed. What is lacking there? We're talking about things that we anticipate will happen into the future, flying cars. But really, what is lacking in addition to this? You have three answers that you can give, and if we can take the poll: belief, imagination, further scientific evidence about the future. When we're ready to publish the results, I'll be more than happy to see what the majority of people would vote for. Until the voting is there, just so you know, over the billions of years that the Earth has been in place, 1% represents the advancement of technology that we see today. And in that 1%, the most pollution of the Earth has taken place during that 1%. Belief, again, I inserted that thinking, I'm really glad that I can think what people may vote for. I thought you would vote for belief, but believe it or not, and I see that there's a division there, it's actually imagination. Now, of course, we can see the bright side of it is that when you imagine something and believe that it will happen, most likely it will. But let me share with you the following. Imagination, that's true, and nonlinear creativity. And that's not my own view. It's what Albert Einstein, decades ago, said. Imagination is more important than knowledge. It's this nonlinear creativity that makes a difference. And this brings me to the point, why did I share with you? When we look about cars or phones, what we're thinking about in phones, for example, handheld devices. This is actually crippling and shackling our vision of how things may evolve. When we think about cars, we think about devices that we need to ride, either through the air or to take us somewhere, self-driving. But who said that there may not be a time where we would have teleportation, especially that today there have been successful applications of teleporting data. Now, biologically, not yet. We have not been able to teleport humans, apart from science fiction. But this, again, part perhaps of another dimension that is quantum teleportation and quantum entanglement, which, by the way, Albert Einstein, when you read his books, called spooky in a way. But this brings me again now to the shocking reality. We talk about artificial intelligence. How can people think that they will be replaced by artificial intelligence? But let me share with you a very recent study that came about out in October 2020, precisely during the first week, the press release. It's by Oracle. Check it. Workplace Intelligence, Artificial Intelligence at Work Study. Now, this comes during the pandemic, which people label as the most stressful year ever. Surprisingly, they surveyed 12,347 employees, managers, HR leaders, C-level executives, and by the way, with different age categories, so it's not the youngsters, across 11 countries: the US, UK, UAE, France, Italy, Germany, India, Japan, China, Brazil, and Korea. Now, what does the survey says? What do you think? Now, we're talking about surveying people about workplace study about their mental health. What percentage of people do you think believe, this is the survey of real people, robots can support their mental health better than human? So we're talking about mental health, emotional distress, mental distress. It's not something very tangible to measure. It's not about an arbitration case where you have X and Y or an expert report with mathematical calculations to adopt. We're talking about emotions and neurosensors and mental health. Can you vote? Can we have a poll on this? Out of this large number, how many do you think? Answer first the first question, or you can answer both actually. Percentage of people who believe that robots can support their mental health. And then another question, what percentage of people believe or prefer to talk to a robot over a human manager about stress at work in 11 jurisdictions? So you have the percentages there. I, for one, if I'm voting for this, I would say 0. I would rather talk to a human rather than talk to a robot. But anyway, we'll see what the survey results show in this respect. Unless, of course, the human is someone you can't have a conversation with at all, then perhaps you don't talk to anyone. Can we publish the results then? Let's see your votes, whether it will coincide with this statistical study. So here we go. We have 20% says 8%, 40% says 82, and again, 40% says 88. Perhaps this was part of my plan to provide an inceptive view in your mind so that you, when you vote consciously, you would vote for high percentages. But anyway, what happens really is the following. The real percentage is as follows. 82% of the people believe that robots can support their mental health better than humans. And for the second question, it's 68%. These are images I did not create. You can find them on the internet. 82% of the humans believe a robot can offer them better advice and deal with their mental health, and 68% prefer to talk to a robot. And just to give you an idea, India and China, for example, the percentages are in the range of 91 to 92%. Japan is much lesser, even though they are very advanced in technology, but these are people's perceptions. So now the shocking reality brings me to my last, before we do that, why people think this way, because they think robots offer a better judgment, offer a judgment-free zone. They're not going to judge you. they're unbiased, provide quick answers to health questions. Now, if I take that, for example, into a traditional legal context of arbitration proceedings, for example, or court litigation, judgment-free zone, perhaps this is a version of being objective, no bias, quick, efficient, and cost-effective process. Can that replace the human element? Well, some people believe so, not necessarily mean, but again, are we conscious of our own biases in favoring or voting for the continuation of things as is compared to artificial intelligence? Again, the situation is for you to decide. 88% of people want AI solutions. Why? Because again, swift, automated administrative tasks, new skills to learn. But what they may not know is that in a very short period of time, they will be out of business. Their jobs will be taken in away. And this is happening as we speak. It is, again, part of either a reality that we want to continue or something that we may wish to reconsider. Now, my concluding then remarks are what we traditionally perceive as a simple use of technology for online cyberspace disputes, be it of defamation, small value, high volume cases in a broader sense. This was traditionally the perception. But now ODR is not just ADR online. It encompasses court proceedings and out of court dispute prevention, management, and resolution. This is a reality. Still, we're in the present. And the final thing is that AI applications apparently, and perhaps scaringly, becoming normative in dispute avoidance, management, and resolution, with predictive justice applications, applications that can digest voluminous documentation and brings you an output instantaneously. This is the real world we're living in. Now, how far we're going to go in light of that, and where we'll be carried forward, be it neurochips implanted in humans, or perhaps a tribunal secretary as a robot in cases of arbitration that can help you with the procedural background, distilling the parties' submissions in a way, all this. Are we going to witness that? We've seen that in China, they have an AI judge who assists the judges with administrative tasks. And my final question to you is what this device is, which looks as a device there on the right-hand side. What do you think there is? That's the final poll before I conclude. What do you think that is? Is it a satellite mobile phone, a lie detector device, a teleportation device, or a portable credit card machine? Again, these are prototypes. They're not for commercial use, but it tells you where the R&D, research and development, is heading and where we are effectively heading. And we can, of course, behind closed doors, sit and say the legal profession is not going to be impacted when, for example, the medical profession is threatened by potentially robots who can do operations with more precision and accuracy. But again, there are myriad of choices out there and a lot of opportunities and a lot of concerns in this. Do we have the published results? What people think that is? Excellent. This is very close, but it is a prototype of a portable lie detector device. And you'll say, okay, what does this have to do with ODR? Let me give you an example. We know about witness testimony and witnesses testifying in arbitrations or in court proceedings. What happens if that is widely proliferated or used to check whether the witness is saying the truth or not? Are we going to trust the results? The witness may be saying the truth themselves because this is what they believe as part of what they convince themselves is the truth. And at the same time, are we going to rely on this, or are we going to rely on still the intangible sense of the human element, the factor that artificial intelligence has not yet captured? Whether it's ever going to capture or not is another thing, but this is the reality. And the imagination that I was referring to brings me to the final point about either holographic visual projections when we talk about virtual hearings, or perhaps quantum teleportation, if that is ever going to happen. I'm not sure where technology will take us, but this is just a snapshot of where we stand. And I stand ready, of course, to address any questions or views you may have. And I apologize that I've taken much time, and thank you for your patience, and thank you very much, Fatma, for the very kind introduction and for the time and the moderation of this session. Thank you. I can't hear you. Are you on mute? The common mistake we all make. You are, I can't hear you. You are still on mute, actually.
Oh, okay. Yes.
Yes.
So actually, I wanted to thank you very much for this very informative presentation. It took us, or at least me, to the multiverse and its different possibilities. And I think we need some follow-up series events to expand on several important points raised in your unconventional presentation that prepares us for very unconventional times. I believe there are lots of opportunities to tap into, but it needs to be done quickly because we don't want to fall behind artificial intelligence. Stephen Hawking said to the BBC in 2013, the development of full artificial intelligence could spell the end of the human race. It would take off on its own and redesign itself as an ever-increasing rate, and humans who are limited by slow biological evolution couldn't compete and would be superseded. I will not take this as pessimism, but rather as an inspiration to move forward and flow and embrace the changes. But the only alarming point, although, is the preference of artificial intelligence to human beings, which, in my opinion, is due to the deterioration of the human condition. And the hope is that despite the stress caused by the pandemic, it might help us make more informed choices that hopefully would restore faith in humanity rather than us escaping towards robots. But I will still be very optimistic about the chances we have. I believe we have a few virtual questions.
And I'm happy to answer them all. If you want, I can take them one by one, but I absolutely second what you say. And let me then recall the memorable words as well of Apple's CEO at the time, Tim Cook, when he said that I don't fear AI computers thinking like humans. What he fears is that humans thinking like computers with no compassion. And I think this ties in with one of the questions that I'm happy to answer. So you want me to take them one by one, perhaps?
Yes,
There's the
please.
first question from Mr. Amr Abdel saying, as one of the best features, the New York Convention for the recognition and enforcement of arbitral awards. Of course, I agree with that. Do you think that there be some barriers for ODR to gain such recognition? That is an excellent question, and the answer is there are barriers. And let me tell you one of the barriers realistically. When the Answer Trial Working Group number 3 was discussing ODR principles and perhaps having rules, and one question that surfaced, okay, ODR or automated decisions of sorts, are they going to be enforceable under the New York Convention? And here the delegations were split and views were split and there was no consensus. So there is this barrier does indeed exist. The question will fall squarely as to whether the countries have provided any reservations. I think none of the two reservations, the commerciality reservation or the reciprocity, raises any concerns. But the point is the use of technology and whether this was in contemplation. Let me tell you that in 2005, there is the United Nations Convention on the Use of Electronic Communications in International Contracts. Article 20 of that convention says that it applies to the New York Convention. So they are taking the ICT component and applies it to arbitral award in that sense. So it is still in its infancy stages, but gaining momentum quickly. The second question, quickly, are ODR platforms secure enough to be reliable and trustworthy? And are humans ready to take the human factor out of the decision-making process? I hope that we're not going to take the human factor out of the decision-making process, but hope
Sorry, excuse me, we seem to be having some technical issue. And I take this opportunity to welcome Dr. Ismail Selim until Professor Abdel Wahab is back. Thank you for joining us.
Thank you very much, Fatma. Thank you. And thank you for the excellent moderation of this event.
Oh, it's a pleasure, and we're very grateful for CRCICA to actually facilitate this presentation at this very important time.
Thank you very much. Thank you. Yes, I see that Dr. Mohamed Abdel Wahab is back. Good evening, Dr. Abdel Wahab. It's a pleasure to have you, and thank you very much for this excellent lecture. So I will give you the floor to
Thank you very much, Dr. Selim. I apologize. I apologize. I think I lost the questions because I rejoined. So perhaps Fatma can educate me on the questions, and I'm happy to answer.
Absolutely. Yes. So the question you were reading was about ODR platforms, whether they were secure enough to be reliable and trustworthy, and are humans ready to take the human factor out of the decision-making process?
As I'm saying, I hope we're not ready yet, but if they are taking the human factor out of emotions and mental health, one could wonder what would not be taken out from the factor accordingly. Security is an issue, and cybersecurity and integrity. There are a lot of, for every, let me say, Newton's third law of motion, for every action, there is a reaction equal in magnitude and opposite in direction. Basically, you have a patch for a security breach, and then another day you have a new virus. There's more than, I think, 45,000 known viruses in terms of computer viruses in a way. So security remains a concern, but there are protocols in place to at least include or provide for minimum guaranteed integrity and cybersecurity. And there are many protocols in place, which I'm happy to share with people if they're interested, of course. And there is ECA, by the way, ECA, Queen Mary, and the Center for CPR in the US. They've combined forces and issued a protocol on cybersecurity international arbitration. So people may wish to look into that as well. Sorry, any other questions?
Yes. So there's one on, do you think that developing countries will benefit from ODR techniques like advanced countries? And if not, how can that be fair?
Look, I mean, technology is not a level playing field. I think there is a lot of benefits from ODR, especially when you're trading online. You don't have the physical barriers. You don't have the cost of cross borders or movement of non-e-goods in a way. So there are opportunities for developing countries and people in those developing nations to do business. So that is helpful to that extent. Now, technology, again, is, as we've seen, a double-edged sword, and it's up to people how they utilize it. But of course, if you hold the funds and the capital, you're able to ensure that technology is on your side. So if you're going to invest in research and development and in technology, so be it, you're going to reap the benefits. But still, there will always be the people who have the capital, will have the leverage and the upper hand when it comes to technology.
Yes. So another question is, in your opinion, is the use of AI eventually replacing judge arbitrators compatible with due process requirements? And despite the neutrality of these robots, do you think that justice will be seen to be done in these cases, since the parties cannot discuss their case properly with the decision maker?
Again, it's a function, that's an excellent question. It's a function of perception. If we remember the imagination, we think of AI judges as the dummy robots we see today, or as the dummy computers we see today. But self-learning machines who may have an element of evoking or mimicking human emotions to an extent, something scary, but it's not a distant possibility. There are results. I, for one, do not wish that the human element to be replaced, since we're humans and we have our own biases to our own race, of course. But I think what we've seen on base of statistics, it seems that the lack of bias and the pure objective stance or stern approach to things may have been to the liking of some people voting in regarding the mental health study. So it seems at least that we know, instead of the world standing united and the human race is united about a big no, there will be a division among people, and a division on the borderline of not just 50-50, I'm a bit concerned that we might be on the side of the minority. So it is an unfortunate a glimpse into the future. I'm hoping it's not a reality still, but that is only a subjective, consciously biased views that I offer.
Then we have a very interesting question. If a robot is hacked or got a virus while making a decision in any field, who would be liable for the mistake and how a sanction would be imposed on an artificial intelligence?
It's an excellent, excellent question. And let me tell you the following, and I don't want to take much time, but these are very interesting discussions. You have to distinguish between robots or machines that only act on the basis of input and programming in a way that you input instructions. So this means that in that sense, if there is a problem, this is the thing. And so the person liable in many legal system is the person who owns the thing or releases the thing. So that's the human ultimately. But there are now situations where you see self-learning, self-aware, self-integrating robots in terms of importing and integrating their own feed-in data in that sense. And so we have even seen that, I think, if I recall correctly, Saudi Arabia has given the Saudi nationality to the first robot.
Mm-hmm.
So you're giving nationality to things, at least from our perspectives. We are now seeing in the US, for example, people who have been following, I think 3 months ago in the US, there was a debate live on the rights of robots. Can you believe that? The rights of robots, and debating the idea that robots should have rights. So it's not about animal rights or living organisms. We're talking about robot rights. So if you speak badly to a robot, will their feelings be hurt if they have feelings whatsoever? So we see now people talking about things that we traditionally believed are reserved for the human society and civilization. But this is the answer, is that we see now new forms of artificial intelligence that have morphosized into, what can I say, human shaped forms of robots. I mean, this is the reality.
So there's also a question on if, as ODR evolving and becoming the general norm of the industry, will delocalized arbitration prevail?
Well, if I read correctly, the delocalized version means that seatless arbitrations in a way, or no venues. I think we already have ODR rules on online arbitration institutions, be it in China, Russia, or the US, where they have really online arbitration fully conducted online. The seat is a legal fiction, and it's kept there just to ensure which courts are courts of primary jurisdiction. But if courts are going to move online as well, one might think or invite a reconsideration of the legal perceptions of the seat altogether. So there will be a delocalized movement into the parallel universe of the internet. And that is where the traditional territorial, being geographical or fictional, approach to territory and seat may fall apart because you're without boundaries in a way.
Which leads us into this question. Do you think that ODR may raise jurisdictional issues or challenges? And what are the existing solutions for them, if any?
I am yet to see a jurisdictional objection to ODR other than if we're talking about a clause in a contract providing for ODR and what falls within that scope or not. That's the only jurisdictional aspect I can think of. Other than that, I can think of enforceability problems, but not jurisdiction-related problems. And the solution, of course, is that you will have, as this gains momentum, either more and more conventions or instruments that brings countries of the world together. For example, there is a pilot project regarding the e-apostille convention, where you're talking about, instead of taking a document to be legalized or apostilled in a certain state physically, you circulate it electronically, free electronic circulation of documentation. Imagine whether this can apply to awards. So instead of you taking the award, submitting it to a Ministry of Justice to deposit it, you're not going to do that. What you're going to do is that you click send, the judge will send it to another judge in a different jurisdiction based on bilateral treaty of judicial cooperation, and no one is going to move from their place. And this I see as happening. I see, and my contribution to you today is that there will be free circulation of judgments and awards in due course with the advent of states buying into the system.
Thank you. And a question on preparation. So how should we as practitioners prepare ourselves for the future coming, particularly when everything is changing so fast? Should lectures on technology become more important in the law studies?
I'll start from the easier part, which is the last part. I think definitely technology should be part of the curriculum. IT law should be part of the curriculum across all the legal curriculum. I think it's inevitable, unavoidable, and a must. The second part, where do we see ourselves in the profession? Let me tell you, based on a discussion I had with a very prominent Swiss arbitrator, the son wanted, and I'm being gender neutral, the son wanted to go into law school. And the arbitrator opposed this firmly because the view expressed by that prominent arbitrator was that you will be jobless. You're not going to have a job. In time, 10 years down the road, and that person told me, I have the fear that the new generation could be out of business. I am not that dramatic or extremist about it, because the way I see it, with the advent of technology, of course, there are certain jobs that become obsolete, but this also opens the door for a new stream of jobs, new services that may open the door. I think we can agree on one thing, that in many countries, investment in IT, investment in technology has become a priority, and the advent of studies to have a league of scientists dealing with artificial intelligence is now on the high water mark and a very hot topic. I think for any organized form of society, law remains important, and so legal practitioners will not be obsolete. The question is who these legal practitioners are going to be. Are going to be us or robots?
Yes, which actually leads me into a comment before I resume the questions. Someone was saying it's all scary stuff, Professor Mohamed.
It is scary, and I align myself with that view. The question is, I always say this, we can't turn a blind eye, we can't hide our heads in the sand. We should confront these questions and have an open discussion as to know where we should be heading, and perhaps advise leaders or people in the decision making whether it's the right time or the right approach to move in a certain direction. And perhaps people should be consulted on whether they want this to be happening or taking place or not.
Totally. And then two interesting questions about robots. So would it be fair to make another race, and between brackets, robots, decide for us? And if a robot is self-improved, it may in the future be biased to his own race, between brackets, machine race.
Again, if they use his, again, we are again looking in a linear type of approach. I'm not sure his or her or its or they or whatever they call themselves, the robots, but I think it would be, what can I say? I would not like us to think that we should have robots take decisions for us as such, as human beings. I, for one, buy into technology, and I've been at the forefront of supporting technological advancement and speaking about technology as it goes. But I think sometimes we feel that things are spinning out of hand. I think technology can support, can help, can guide, can give us tools to assist, but to completely take over, and so our very existence become futile, to use the Borg in Star Trek, resistance is futile. I don't want to live in that world. I don't want to live in the world where we become an obsolete race or an inferior race, or, I mean, it's going to be shocking, but I don't know.
Which actually leads us to the last question that says, on the premise that there may be human elements in the decision-making process that can never be replaced, should the development of ODR be strictly limited? And secondly, if unlimited development of ODR is permitted, is it likely that ultimately robots could evolve unchecked into bad decision makers?
It's an excellent question, and I think it proves that my my discussion with you today and presentation must have left a mark. And let me take an immediate response to that, a short one, by saying, no, it should not limit or restrain ODR, because if we choose an approach where the human element would remain the third neutral, third party neutral, with technology as the fourth party, this means there is room for both. The challenge is that if the fourth party threatens the very existence of the third party. So it's not about ODR, it's about the applications that are being developed to completely dispense with the human element, or to move into the approach and the direction where these applications are to serve the needs of society and assist the human element in taking decisions when a third-party intervention is needed. I, for one, for example, accept the fact that you can have fully automated negotiation systems, one-to-one, generating win-win situations. But if you want to have the intervention of a third-party neutral, a decision maker, I would like to think that the human element would continue to have a role to play. I think that's a neutral statement that I would make.
I completely agree with you. As much as I enjoy the webinars, as much as I miss the human interaction and seeing people face to face, and I would never want that to be replaced. So I join my voice to yours. And thank you very much for this very, very informative presentation.
Thank you very much, and for your patience. And I fully align myself with, I miss, to tell you the truth, I miss shaking hands with people. I miss talking to people face to face. We all now have our concerns and fears. When you have a friend walking up, you still, should I approach them? Should I stay afar? These things, the things that we have taken for granted for a long period of time, I think we have now been shown that the threats by an invisible virus is putting us back in place to see that we are not the creators. I think this is a very important message. But anyway, that's it. And I assume that we learn from our experiences and we will not have short memories of the lessons to be learned, and that we will make best use of technology to ensure that the double-edged sword is not going to be a cause of our very own extinction. Thank you very much, Fatma, and for the Cairo Regional Center, Dr. Salim and Ms. Roshdi and her excellent team. And I must say, I'm very grateful for the opening video, and I would like to have a copy of that. And I feel that I'm gaining weight by staying at home as well, so I don't want to see myself as I've seen myself in the video again. So hopefully not. Thank you again.
Dr. Ismail, you had a very important announcement to make.
Thank you very much, Fatma. First, to reply to Dr. Abdel Wahab regarding the opening video, you have it on your WhatsApp now, so you will find it.
Thank you.
It's sent to you 1 hour ago.
Thank you.
So you have it as a short video. It's I have to thank our archiving team at CRCICA. We found many VHS videos that we were able to save and to save on our hard disks and our machines to keep our history. And so you are part of CRCICA's history undeniably. And we found several videos of yours speaking in different conferences, and one of which was on online dispute resolution, as you have seen, or several even. Well, I have an important announcement. A few months ago, I requested from Dr. Mohamed Salah Abdel Wahab to link me with the specialist of online dispute resolution. So he kindly introduced me to Colin Rule, who is the chairman and CEO of arbitrate.com, which is a service provider of online dispute resolution. So I had a discussion with Colin, and we discussed whether in Egypt and in the region we use fully online dispute resolution services. I told him not yet. Of course, we use video conferencing, virtual hearings, but it's not what Dr. Abdel Wahab has explained today, and it's not. This is not ODR as it exists. So I told him we should start with training people, training our arbitration practitioners on fully online dispute resolution services. So he told me the training is a very good idea. So we decided that we, arbitrate.com and CRCICA, would organize a training on online dispute resolution. And we had the idea of introducing our audience to such a training with this very valuable lecture. And I thank Dr. Abdel Wahab very, very much for this very valuable lecture. And I'm happy now to announce the dates of the training. You will receive the flyer of the training very, very soon. I hope it's going to appear next Sunday. And I have to thank very much the CRCICA conferences team and the CRCICA IT team. I thank them very much for this webinar, for this very successful webinar. And I'm certain you would notice that it was done even better than usual. We were very much keen on pampering Dr. Abdel Wahab, first with an excellent moderator like Fatma, and also to match this very valuable speaker and very rich lecture. And so that's why, in terms of the technology used, the background, we have done our best in order to make it materializing different than usual. So I thank very much my team, and I thank them also for their work and for their future work to make the ODR training successful. So the training will be co-organized by arbitrate.com and CRCICA. It will start on Monday, 2nd of November to Thursday, 5 of November. This will be the first week. Every day, 2 hours from 5 p.m. to 7 p.m. Cairo time. Then the second week from Monday, 9 November to Thursday, 12 November from 5 p.m. to 7 p.m. We will request, of course, from Dr. Abdel Wahab some recordings to be part of the training, even though because of Dr. Abdel Wahab's very busy schedule, he will not be able to be with us like today, but we will use some of his recordings. And we will have top leaders in the online dispute resolution, Colin Rule, Benjamin Davis, and Mirez Philippe, and also Amy Schmitz. So in this training, we will offer a comprehensive overview of online arbitration best practices and standards, including clauses, arbitration clauses, rules, claims and counterclaims, constitution of tribunals, and disclosures, as well as simulations focused on hearings, evidence, and cross-examinations. This training will provide hands-on opportunities to try out online arbitration tools, participate in simulated online hearings, and draft clauses and awards. Participants in the full course will also receive certification in online arbitration from arbitrate.com. There is also an option to participate in some of the days and not all the training, but you will not receive the certificate in this case. So we welcome those practitioners who already have a significant experience in offline arbitration to participate in this online arbitration training. So we hope that we will have many participants. This is the announcement. And then you will wait for next Sunday when you will receive the flyers, the flyer of the training. We will send it by email, and you will find it also on our social media pages. Thank you very much, Dr. Mohamed Abdel Wahab. See you very soon. I'm waiting for you.
Thank you very much, Dr. Salim. Thank you very much, and good luck with the training. You will be in very capable hands, and I'm delighted. Unfortunately, I'm in hearings, in virtual hearings during that period, but definitely I wish you all the very best. And I think the CRCICA has took it to a completely different level with the ability to navigate well during the COVID-19 in terms of enabling the arbitration snowpiercer to continue. I call it the snowpiercer because when courts sometimes stopped and closed their doors, arbitration continued to be open to render services. And I think the CRCICA managed that very efficiently. So kudos and grand thanks and congratulations to everyone at the CRCICA with great pleasure. And I think that's it. Thank you very much. I spoke too much today.
Oh, no, it's a pleasure. It was a pleasure. Thank you very much. Thank you very much, Dr. Abdel. So I leave the floor to Ms. Fatma Ibrahim. And thank you very much, Ms. Fatma, for your enthusiasm and your excellent moderation of this marvelous lecture.
Thank you. Thank you very much, Dr. Salim, Professor Abdel Wahab, Ms. Hiba, and the IT department. A very informative session, and we look forward to more. And I wish the attendees a very good evening.
Thank you.
Thank you.